Good morning. May it please the court, Mark Gottlieb of Ackerman LLP on behalf of NationStar. I'd like to reserve 5 minutes for rebuttal if that's okay.
Very good.
And before I get started, I just wanted to note one thing. Mr. Stopa has filed this morning a bunch of supplemental authority which appears to be directed to the issue of prevailing party attorney's fees. My understanding from talking to him before we came in is that he intends to devote at least some portion of his argument to the attorney fee, the pending motions on attorney's fees. My intent this morning was to address the substantive merits of the appeal, but obviously if the court has questions regarding the fee issue, either now or on rebuttal, I'm happy to answer those questions.
Thank you.
The lower court in this case erred in granting Mr. DeCoursy's motion for involuntary dismissal at the conclusion of NationStar's case in chief at trial, construing all of the evidence and inferences in a light most favorable to NationStar. NationStar made a more than inadequate showing of standing at trial, both standing of the original plaintiff, Aurora Loan Services, which Mr. DeCoursy conceded, and NationStar standing from the time it substituted in as the party plaintiff through the time of the trial in this matter when the note was surrendered and presented and filed and admitted into evidence at trial. And to the extent that this court were to conclude that the record and evidence presented at trial was insufficient to establish standing, and the trial court abused its discretion and committed prejudicial reversible error in excluding relative evidence that was probative of standing, specifically assignments of mortgage and a power of attorney under which those assignments of mortgage, or one of those assignments of mortgage, was executed, because those documents demonstrated NationStar's right to possess and control the note, to reclaim it from the court file, which goes to the issue of constructive possession. And that's really the fundamental issue here, is one of constructive possession, and why we think this case is distinguishable from Jawai, and I never know how to quite pronounce that case, and Creedon, and also the court's decision in Houck, and even the recent decision that was issued in Partridge. In order to establish standing as the holder of a blank endorsed instrument, a plaintiff must demonstrate possession of that instrument at 2 times by this court's precedent: the time of filing of the foreclosure and at the time of trial. Mr. DeCoursy conceded again that Aurora had standing at the time this case was commenced and filed, that it possessed the blank endorsed note. There is no dispute in the record that Aurora placed that note into the court file, and then Aurora requested that it be substituted out as party plaintiff, saying that it had transferred all of its rights to service and enforce this loan to NationStar, and that was granted without objection. So then the question is, for NationStar to establish that it had standing at trial, it had to prove possession. But possession sufficient to establish standing doesn't have to be direct physical possession of an instrument. Florida law has evolved to recognize the concept of constructive possession. Then constructive possession is enough to give somebody holder status. In other words, a plaintiff can be a holder of a note that is located somewhere where that plaintiff has the right to reclaim it and possess it. They have the power to exercise control over that instrument. That concept has been recognized by this court in its Fan decision. Fan cited to the 3rd DCA case of Dector versus Menendez, which is probably the seminal case on that topic. The 4th DCA has recently expanded upon that in Caraccia, and also in the Raffaelli case that we noted as supplemental authority, very recent case. And the test that those cases establish for constructive possession is, does the plaintiff have the power to exercise control over that instrument? Do they have the right to reclaim it and deliver it to the court on request? Typical examples where that constructive possession exists and has been found are cases where the note is in possession of a servicing agent, the note is in possession of an attorney, the note is in possession of a contract custodian, which frequently is the way pooling and servicing agreements are set up. You have the trust that owns it, and there's a third-party contract custodian that possesses it. In all of those situations, the real party in interest has the right to reclaim it from the attorney, from the custodian, and as a result of that, they have constructive possession. And that's enough for holder status. There is no reason why that same rationale shouldn't apply to notes that have been placed in a court file. The rules of judicial administration, in particular Rule 2.4308.
Do we know who ordered the note to be produced at trial?
The request to produce it at trial was made by NationStar.
Okay, and the trial court exercised its control over...
The note was delivered and was present at trial at the request of NationStar and was in the witness's hand at trial and introduced into evidence. Again, the rules of judicial administration make it clear that the clerk holds documents, promissory notes that are filed with it, in a custodial capacity. It doesn't own those documents. It holds them on behalf of the parties that place them there, and it returns them in the ordinary course. It happens every day upon request of the party. At a conclusion of a case, upon dismissal, in the event of a loan modification, whatever it may be, the clerk acknowledges that there's a custodial capacity in which it holds the notes and returns those to the party that's placed them there and that requests them. As an example of how the arguments that are being made by Mr. DeCoursy could lead to extreme results, if Aurora had not transferred servicing rights in this case and had remained the plaintiff throughout and had filed the note as it did in the court file and never took it back and just showed up at trial, we could not credibly argue that Aurora had somehow forfeited its status as a note holder and lost its standing because it took the note and gave it to the clerk and never reclaimed it in advance of trial. At all times, it would have been deemed to have constructively possessed that note because it had the right to reclaim it from the court file, the right to ask the clerk for it and get it back. And that's what constructive possession is. And once NationStar substituted in as the party plaintiff for Aurora, it acquired that same right and power as the party plaintiff to reclaim the documents that had been placed by the plaintiff into the court file. And that gives it constructive possession of the note, and that entitles it to claim holder status as evidence of what transpired at trial, where it requested the presence of the note and handed it to the witness and admitted it.
Why doesn't our case in Partridge, which was the subject of a supplemental authority notice several days ago or a week ago, why does that not control? Because in that case, NationStar's position was the clerk is holding it at our direction. We asked the court to take judicial notice, so the court recognized that we've asked it for judicial notice and so forth. And our court said, it's not enough. That's not enough to establish constructive possession.
Well, I don't know that it's entirely clear that all of the constructive possession arguments were advanced on the face of the decision, which I know is not even final yet. But the important distinction in Partridge is that the note had been placed in a court file by a different party in a different case. NationStar was never a party to that case. The note was never placed in the court file in the case in which NationStar was a party. And that is what makes it possible.
NationStar filed a certification stating the note and mortgage are already with the trial court, asked the trial court to take judicial notice of the originals and transfer them to the NationStar foreclosure case. The trial court granted the motion, which suggests that NationStar was exercising the same level of control as it is claiming to have exercised in this case.
Well, I think it is different only in the sense that the note had been filed in a different proceeding. And that seemed to be a focal point of the argument.
How is that a distinction when the court granted NationStar's effort to control the note by transferring it into the new foreclosure case and taking judicial notice? I don't understand what your distinction is.
Well, again, the distinction, I understand that it had been transferred over. The distinction is that it had been placed in a court file in a different proceeding and then moved later in the case. But I would...
So it's not the fact of exercising control then that you're saying is determinative?
It's the right to exercise control.
Well, NationStar had the right to exercise control in that case because the court allowed it to exercise control.
I understand. I believe it to be factually distinguishable, but to the extent it's not, then I would urge the court to revisit the issue, and I understand that decision is not yet final and it is subject to rehearing, because as a practical matter, it doesn't serve the purposes of, under the code, of why we even care about possession to begin with. It's creating rigid and artificial requirements that are inconsistent.
Counsel, if we're going to talk about practicality, how hard is it for a bank, and I'm not faulting NationStar in this case, but we've seen case after case where there's an assignment of mortgage and there's no assignment of the note. Documents are lost and then they're found and they're filed or not filed. You know, we've seen, I don't know how many colors of Crayola we can find on the same issue, but we keep finding new colors. And this just seems to be a practicality issue. Why isn't the bank doing it correctly to begin with?
Well, first of all, the law continues to evolve. The idea that a substituted party for a party that had possession and clearly had standing at the case, when the case was filed, that party, when they substituted, wouldn't acquire that party standing is something that's evolved in the law over the last several years. The idea that you would have to separately get an assignment of note and mortgage until rulings in Creedon or July, I don't think would have necessarily or naturally occurred to people, because Aurora was the holder of the note. Aurora walked into court and represented to the court and secured relief based on this representation. We have transferred all of our standing to NationStar. They are now the real party in interest with the right to enforce.
That was not an evidentiary proof, was it? That was an argument to the court saying, we're washing our hands, here's the party, please let us out, let them in. I mean, that is not an evidentiary determination of standing.
It's not an evidentiary determination of standing.
It's a substitution of a party.
Substitution of a party, but there are plenty of cases that say...
The Supreme Court has said since, I don't know, the 1800s that you've got to prove standing at the inception and at trial. And
there are also countless cases that say when an original party has standing, an order of substitution conveys that standing to the substituted party, including the 4th DCA very recently in the Raffaelli decision, which is very, very factually similar to this case. In that case, you had what you had here. You had an original plaintiff, a loan servicer, who filed an action as a note holder. They possessed the note on behalf of an owner. They filed the note in the court file. And then they substituted another party plaintiff. And the court, the 4th DCA in that case said, the substituted party acquired the standing of the original servicer that was the holder without any independent proof or requirement and was entitled to enforce the instrument. No separate proof of possession or assignments of mortgage or anything else was required in that case. And again, going back to why we care about proof of possession in the first place, because blank endorsed instruments are bearer paper. And so we're concerned that when they're floating out there in the stream of commerce, we need to know who had them when, because whoever had them had the right to enforce them. None of those concerns are present here. We know where this note was at every material moment. It was in the hands of Aurora, which then said, we've transferred our rights to NationStar, make them the substituted party. They had put it in the court file where it remained at all material times, where NationStar had the right to reclaim it and did in fact reclaim it at trial. And to further that point, if this case, if the dismissal stands and this goes back down, this note is not going to sit in the court file for time immemorial, waiting for somebody to claim it. NationStar is going to retake possession of that note as the party plaintiff and then file a new foreclosure. And it would be absolutely within its rights to do that. But the fact that it didn't retake possession before trial shouldn't be dispositive under Caraccia, under Fan, under Dector. The fact that it had the right to possess that note gave it constructive possession and gave it holder standing. And to the extent that the court is concerned that the substitution alone doesn't do it, the evidence that was relied on for the substitution was actually introduced at the trial in this matter. So at the trial was introduced evidence of the servicing transfer, including the statutorily required hello and goodbye letters that admitted for the truth of what they stated under the business records exception without objection, that specifically stated that all rights to service, collect, and enforce this note have been transferred from Aurora to NationStar. You had both the Aurora letter and the NationStar letter. You had other servicing records to that effect, including Exhibit 12, which was a screenshot specifically showing, admitted for the truth, that this loan had been transferred and acquired by NationStar from Aurora, being serviced on behalf of investor Fannie Mae. You had testimony from the witness to that effect. So even if the court is disinclined to find that the substitution alone gave NationStar the power to possess and control this note, and therefore constructive possession, there was independent evidence. And again, on an involuntary dismissal, all of that evidence is to be construed in NationStar's favor, that showed that they had acquired that right, that they had acquired that power to control and possess the note and pull it from the court file at their will. It should be no different than if they had placed the note with an attorney or with a custodian and elected to retrieve it on the day of trial. They had the power to get it, and that's what should matter for the purpose of holder standing. And again, given what the concern is, because we know where this note was at all material times and it wasn't in the stream of commerce, What are we worried about in this case? Who do we think is going to show up and claim that they're the holder? This note has been sitting in a court file. The only other conceivable party would be, which would be Aurora, would be judicially estopped because they represented to the court that they no longer had an interest, and they secured relief based on that. They don't even exist as a loan servicer anymore.
Mr. Gottlieb, you're at your 15-minute mark.
Good. Thank you, Your Honor.
Thank you.
May it please the Court. I'm Mark Stope. I represent the appellees. Your Honors, unless the Court has questions, I'm inclined to be very brief on the merits and to try to use my time to argue why the amended motion for attorney's fees, which we filed in connection with this appeal, should be granted. On the issue of the merits...
So are Raffaelli and our court's more recent case, Partridge, are they in conflict?
Not at all. Not at all, Your Honor. Because the concept in Raffaelli and Caraccia is dealing with constructive possession in the context of a servicer possessing the note on behalf of the plaintiff, the plaintiff's own agent, as opposed to the clerk of the court. Creed and GY and Partridge are this court's controlling decisions, which all make clear that when the note is filed in the court file by a different entity, and then another entity comes into the case, either a new suit or by a substitution of party plaintiff, that new entity is not the holder of the note as a matter of law. There are no DCA decisions which are contrary to that. My opponent's arguments based on constructive possession simply don't apply because those cases are only in the context of a loan servicer acting on behalf of a plaintiff trust or something to that ilk.
Doesn't Raffaelli, I'm trying to remember factually, isn't that pretty much on all fours with what we have here? What's the distinction?
Judge, my recollection from it is that the constructive possession argument was made in the context of the clerk being the agent as opposed to the servicer, and in that case it was a servicer as opposed to the clerk. I haven't seen any conflict in any of these decisions.
I'm looking at Raffaelli right now, and it says the original servicer attached a copy of the note to the complaint, filed with the court the original note 2 years later before substituting the note owner. I think the note stayed with the clerk.
Yeah, my reading of Raffaelli, Your Honor, is that it was the same as Caraccia and Fan, in that in all three cases the constructive possession concept was being argued with respect to a loan servicer for the plaintiff as opposed to the clerk of court or anything of that ilk. So, perhaps Your Honor's reading that differently. I didn't read Raffaelli to in any way be in conflict with Creed and GY or Partridge, which are the controlling decisions from this court on the issue. Certainly, the Raffaelli court didn't indicate there was any sort of conflict or anything like that at all. So,
I think our court actually was the second one, so we didn't indicate conflict with Raffaelli.
Well, I believe Creed and GY certainly came out before.
Partridge is the one.
Right, Partridge came out after, right, but Creed and GY came out before Raffaelli, and I submit if the 4th District thought that there was conflict, then they would have indicated so, and there was obviously no indication of that. So I submit that those cases are all easily reconciled based on that distinction, which is the operative one, and that this court's decisions in Creed and GY and Partridge are the controlling ones on the fact pattern at bar. I think it's notable also my opponent didn't even argue this in the context of certifying conflict or anything like that. No request for that in the briefs. They're just essentially asking this court to disregard 3 of its own decisions, 2 of which are final. The GY decision is precisely on all fours, and GY is the very distinction that my opponent tried to make on the Partridge case. So in terms of the merits, it's very clear this court's decisions require an affirmance on the merits. Now, on the issue of attorney's fees, which I submit is the only reasonably disputable issue on the fact pattern at bar, I submit that we are entitled to attorney's fees in the event that this court affirms the lower court's judgment of dismissal. I want to start out that analysis with under 57105 sub 7, the reciprocity provision, and I don't know if Your Honors contemplated this issue before an oral argument, but I did do a 20-page amended motion to tax attorney's fees that laid out a whole bunch of authorities on this issue, where in a variety of contexts in the law, Florida law has been clear for a number of years that if there's a contract which has a fee provision in favor of one side, and the party moving for fees prevailed in the case, and that contract exists, that attorney's fees are required as a matter of law. That goes back to the Florida Supreme Court's decisions in Katz and David in 1989 and 1990, which create an operative distinction in the law, which all Florida DCAs have followed until very recently. And that is, even if a contract is unenforceable, if the contract exists, then there's fee entitlement. That's under Katz, Florida Supreme Court 1989. Under David, the Florida Supreme Court said the following year there was no fee entitlement because the contract never existed. So if you have a contract that doesn't exist, then there's no fee entitlement. If the contract exists, even if it's unenforceable, then there is fee entitlement as a matter of law. And
one thing that perhaps was lost in this case, there's an assignment of mortgage to Nation Star, if I'm recalling correctly.
Yes, Your Honor.
And that was admitted into evidence, correct?
Yeah, without an assignment of the note, correct.
The assignment of mortgage that was executed some years earlier.
Correct.
And that assignment of mortgage would seem to have made Nation Star a party to the mortgage.
That's
right?
certainly part of the position that we took in the amended motion for fees, is that there was no conveyance of the note, but in terms of Nation Star being a party to the mortgage, that's what the evidence reflected.
And the mortgage has a fee provision.
In paragraph 22.
And they sued to foreclose the mortgage.
They unsuccessfully.
And they lost.
Absolutely. And I submit that is likely one of the reasons why.
It seems to me, Mr. Stopa, you might have buried the lead, because if they're a party to the mortgage by virtue of the assignment, there's a fee provision.
The law is evolving on these issues. Unfortunately, the third and fourth DCAs, as I suspect the court is aware, has issued decisions which may suggest otherwise. They haven't directly addressed the concept of an assignment of mortgage without the note, if that makes...
We don't know what was argued to them. We just know they ruled based on, look, you didn't prove standing, so if you don't have a right to enforce the documents because you don't have standing, you don't get, the winner doesn't get fees. But here, you know, you've argued for fees, you argued it in the trial court, as if I recall correctly, or filed the motion. We have the note, the mortgage of record anyway, and they're a party to the mortgage by virtue of the assignment.
That's certainly how I see it. Now, I would submit an alternative argument as well, that I submit even if Nation Star hadn't shown that it was a party to the mortgage, that the reciprocity provision of 57105 still should have required attorney's fee entitlement, based on the case of the Katz-David, what I call the Katz-David distinction, the two cases from the Florida Supreme Court, as well as all of the DCA decisions which have followed that distinction since that time. For the last 27, 28 years, Florida law has only denied fee entitlement in a situation like this, where there's a contract which has a fee entitlement for one party in two circumstances. One, if the contract never existed, such as if the contract was procured by fraud, like in the Mestry case from the 5th DCA 2015, or two, if the party moving for fees was not a party to the contract at all, if the prevailing party was never a party to the contract. But where the prevailing party is a party to the contract, and that contract exists, then every Florida court since 1989 has uniformly required attorney's fee entitlement under 57105 sub 7. This court did so in the foreclosure context in Tunison. That was a voluntary dismissal. This court did so in Vivo in a foreclosure case. That was a lack of prosecution situation. Now, there are a variety of other contexts in the law as well. Unfortunately, where the analysis started to become a little muddled under Florida law was with the HFC decision from the 5th DCA, which had an unusual fact pattern. In that case, the defendant won a defendant's motion for summary judgment by affirmatively proving that the plaintiff lacked standing. And based on that proof from the defendant of lack of standing, the 5th DCA ruled that there was no fee entitlement. Now, I submit if you were to read that HFC decision and all of the cases cited within it, all of the cases that it relies upon for that proposition are distinguishable based on the Katz-David distinction that I've articulated to your honors, and that the decision is hence respectfully not correctly decided. Unfortunately, based on that HFC decision, the third and fourth DCAs decided Fitzgerald and Glass, which are also ruling that there is no attorney fee entitlement in the foreclosure context, but they even take it a step further. There it wasn't the defendant who affirmatively proved the plaintiff's lack of standing. That in those cases, it was simply the plaintiff did not meet its burden of proof, and when the plaintiff didn't meet its burden of proof and the defendant prevailed, a fee entitlement was denied. I respectfully submit there is no way to reconcile the Fitzgerald and Glass decisions with the operative distinction created by the Florida Supreme Court in Katz and David, and that's why all of the cases that are cited within those Fitzgerald and Glass decisions, all of those cases are distinguishable based on the Katz-David distinction that I've articulated to Your Honor. In every one of the cases that they rely upon, there was either the party moving for fees was not a party to the contract at all, or the contract never existed, such as because it was procured by fraud. If you don't have one of those two things under Florida law, there has to be fee entitlement under the reciprocity provision of 571057. To rule otherwise creates some really absurd results. For instance, it's clear under this court's precedent and the first DCA and others that a voluntary dismissal of a foreclosure case requires attorney's fees. So if the lender shows up at trial and realizes it can't prove its case and takes a voluntary dismissal, then attorney's fees is a matter of law. Now, imagine a slightly different scenario. Instead of showing up at trial and taking a voluntary dismissal, the lender shows up at trial and decides, I'm not going to present any evidence at all. And they force the court to enter the dismissal involuntarily. Well, as the lender would have it, they take the position that it essentially played out the same way. The lender shows up at trial and can't win and presents no evidence, that because it intentionally chose not to introduce anything, that somehow means that the defendant should not get prevailing party attorney's fees. Respectfully submit that is not and can't be the law. And where I think the problem started is go back to where the HFC case was decided. In that case, the defendant prevailed by proving the plaintiff lacked standing. So it's couched in terms of judicial estoppel. And I can sort of get the concept of judicial estoppel in this context if the defendant comes in and proves, hey, there was no contract here. After all, that's what Mestre said as well, and there's other cases. If the contract doesn't exist, such as it was procured by fraud, and the defendant proves that, then there's no fee entitlement. That makes sense. But that's a different scenario than Fitzgerald and Glass, where the defendant does nothing. Those defendants didn't present any evidence. They didn't prove any issues. They shouldn't be stopped from anything because they didn't. It's not like they came and said there is no contract, I didn't sign that. That signature was forged and they won because of that. They just sat there and did nothing, and the plaintiff didn't prove its case. I'm sorry, when the plaintiff does not prove its case, just like in the voluntary dismissal context, if there's an involuntary dismissal where they don't prove their case, then fees have to result from that. That's how the law has been for 37 years. Now, there are more...
Have you come across any cases where if a plaintiff did not prove standing, that they were still tagged with fees under the general 57105 statute, that there was no basis in law or fact to bring the lawsuit?
5715 sub 1?
Yes.
Yes, there's a case from this court called Golden, which actually reversed the denial of attorney's fees under 571051, and that was a case where I remember Les Conklin was the prevailing appellant's counsel. I don't remember which judges wrote it, but the lower court denied 57105 fees, and this court reversed required fees under 571051, where the plaintiff knew or should have known that it lacked the requisite standing. It didn't do so under sub 7, but did so under sub 1. The knew or should have known lacked the requisite legal or factual support. I have looked for case law in Florida in other contexts on when a plaintiff can't prove standing if fees were granted under the reciprocity provision. I did not find any one way or the other on that specific narrow issue. But frankly, when I got to thinking about it this morning and was envisioning in my head this argument playing out, I did some research before I came in other jurisdictions, and that was, and I apologize, I hate doing notices of supplemental authority the day of. I realize it doesn't look great. I'm sorry, Josh?
You don't hate doing this. You do this almost every day.
I try not to, Judge. It's hard because the law is always evolving so much. Let me rephrase. I hate doing it where I'm citing cases that aren't recently decided. And these cases, it just...
And we appreciate that.
And so these decisions are not recently decided, but what I found is in other jurisdictions, they agree with the argument that I'm making here, because I found cases from California, Utah, the Supreme Court of Utah, Connecticut, and New York, which have all held that the reciprocity provision under those state statutes, which are essentially the same, required attorney's fees even when the plaintiff could not prove standing under the underlying contract. And so when you look to other jurisdictions agree with the argument that I've set forth in the amended motion, disagreeing with the analysis in Fitzgerald and Glass. And so I submit that the Fitzgerald and Glass analysis is simply not correct and inconsistent with longstanding Florida law because they emanate from the HFC decision, which itself was wrongly decided and is distinguishable, goes back to the distinction of the defendant didn't prove anything. We didn't submit any evidence. We didn't have testimony like in the Mestry case that the signatures were procured by fraud. If we do nothing, if we just sit there and the plaintiff can't prove its case, we have to be able to win. I try to spell out in the amended motion some absurd consequences that would transpire if that's not the law. You even have one here, an example of one. Suppose a plaintiff, a lender in a foreclosure case realizes that they can't prevail based on paragraph 22. They realize halfway into the case, oh geez, we didn't send the letter, and its case is being defended. Are they ever going to take a voluntary dismissal are they ever going to? Why would they? Why would they? If they take the voluntary dismissal, there's going to be fee exposure. You know what they do? They have the perverse incentive to continue litigating that case all the way to trial, come up to trial, and simply not introduce the note into evidence. They can intentionally withhold evidence of standing so as to generate an involuntary dismissal based on lack of standing, and then say, well, you don't get fees. And they weren't going to win based on paragraph 22 anyway. And you don't think they would do that? I've already had people tell me that they plan to do that. That's the system that would be created if you stick with Fitzgerald and Glass. That can't be the law. Let me give you another example. Suppose you have a lender which realizes it didn't send
Mr. Stopa, I think we understand the issue.
Okay, thank you, Your Honors. So I submit that and sorry if I went a little overboard there, but I submit that there should be an affirmance on the merits and that we should be entitled to attorney's fees, notwithstanding what the other DCAs have ruled in Fitzgerald and Glass.
Mm-hmm. Thank you.
Thank you, Honors.
Mr. Gottlieb, I do want to ask you about the fee issue. My recollection is the note was proffered, the original assignment of mortgage was proffered, the assignment of the mortgage and note that were executed just before trial were proffered. But there is no dispute, if I recall correctly, that your client had the assignment of mortgage such that it was entitled to at least try and foreclose the mortgage, correct?
There were assignments of mortgage and assignments of mortgage and note, but here's the problem. They can't have their cake and eat it too. They successfully excluded all that. It's not in the record. It wasn't admitted into evidence. They argued that it wasn't proper and not admissible and successfully defeated the admission of those documents in the claim of standing. If those documents had been admitted, we wouldn't be having this conversation. Under this court's precedent, we'd have an assignment of note and mortgage, we'd have standing, and we wouldn't be talking about fees.
The lawsuit that was filed, if I recall correctly, was it a verified complaint? Do you recall?
This lawsuit?
Yes.
Probably not. Originally, it was an 08 case. I don't think the verification requirement existed.
But you're not disputing that your client, I guess the bottom line for me is, I understand there was no real dispute your client had the assignment of mortgage. The real dispute was, did it include the note or was the corrective note later? And if you say we're not conceding that, then why would this not be a case for 57-1051 that you had no basis in law or fact to bring this lawsuit?
We had every basis in law and fact to bring it.
Based on what?
We affirmed
Based
on an assignment of note. Well, first of all, based on the constructive possession arguments that I've made already, independent of those assignments of mortgage, that by substituting in as party plaintiff for the party that had the note and that put it in the court file, that the right to possess it transferred to us at that point in time. And that's a colorable, good faith argument, well supported by precedent. I know that Mr. Stope has made the argument, constructive possession only applies in the case of a servicing agent. That's simply not true. custodians, attorneys, servicing agents. An agency or relationship is one example of where that control might exist, a right to possess or control. But the test announced by the courts is it somewhere that the party has the right to reclaim it and deliver possession? And again, I would urge this court to rethink this issue to the extent that the court thinks that a note placed in a court file doesn't belong to a party and is not subject to being reclaimed by the party, the same way the party can reclaim it from their attorney, from their custodian, from their servicing agent, and that is the touchstone for constructive possession. Otherwise, we're left with the conclusion that notes placed in a court file are just in some twilight zone where nobody has the right to claim them and nobody has the right to possess them. The law here has evolved to a common sense notion of constructive possession, right to possess. It's not limited to agency, and I submit that a promissory note that's stuck in a court file is held in a custodial capacity and the party has the right to possess it is the plaintiff, in this case, NationStar. So we absolutely had every colorable basis to bring this claim irrespective of the note and mortgage or the assignment of the note and mortgage, but they successfully defeated the admission of those documents and defeated standing. Had those all come in, if they want to stipulate that those are valid, then let's stipulate, and then we'll have standing under this court's precedent, because assignment of note and mortgage together clearly establishes, under any scenario, under any case, Creedon, July, whatever you want to apply, conveys standing. And so they can't have their cake and eat it too. They excluded them. The principles that were announced by the courts in Fitzgerald, in Glass, in Alexander, and the third, fourth, and fifth BCA's cases are directly on all fours here, are based on estoppel principles. Okay? They advanced an argument and they won. They excluded all these records. They successfully argued that we weren't a party entitled to enforce the note or the mortgage because the mortgage is deemed to follow the note and that we didn't have it. We weren't the party to it. We weren't entitled to enforce it. That's the argument that's made in virtually every case. And the third and the fourth and the fifth, the fourth en banc, with everybody concurring, said that based on estoppel principles, you can't have your cake and eat it too. You can't successfully argue that the plaintiff was not the correct party in interest under the note or the mortgage, had no rights to enforce them, and then turn around and seek to enforce that same note and mortgage against the party that you successfully advanced that argument with respect to. Really quickly, because I know I'm limited on time.
15 seconds.
Okay. With respect to these other cases, these Supreme Court cases that he's arguing are inconsistent, they're actually completely consistent. What they say is that the attorney's fee provision doesn't apply where a contract didn't exist between the parties. That's the operative thing. He's trying to say that when a contract exists, that the fee provision is enforceable. But if you read
Mr. Gottlieb, that brings us to the end of your time. Thank you.